Good afternoon, everyone.
Good afternoon.
Thank you. Here. Sorry, I had to move so I was in the sun because I drove all day and it's, yeah, anyway. I am Katherine Henry, so I know some of you, and some of you I don't know. It's a little creepy hearing my own voice on this like that. I'm sure I like that. So, unfortunately, I wasn't able to be here all day, so I haven't heard what you guys have heard, and maybe you guys know exactly why I'm here, and maybe you don't, so I'm going to just kind of back up a little and give you some information. I assume these days everybody kind of knows that I'm the loudmouth that's been giving the legislature and the governor a hard time since April, but in case you don't know that or very much more about that, than that about me, I wanted to at least tell you who I am. So, I was born in the UP, so I am from Michigan originally. I did actually grow up in Orlando and spent my summers in the UP once my parents got divorced. Spent 10 years in Minnesota, and I've been back in Michigan now for 12 or 13 years. The older we get, the more it blends, right? I am a proud mother of 4. Youngest child of 4, Emma Christine. Emma, you're being called up here. Emma. If I say this is my favorite, will I get the Snickers? Like, you can't have that. She's 6. The other ones are 17, almost 17, and 19. So now if I say she's my favorite, do you understand why?
It's fair. Please.
Okay, I can do whatever you want. Go ahead. And she's not in public school anymore. So I homeschooled anyway, but I had her in public school last year because I was doing restorative justice in a school district that needed some assistance with kids who had a lot of troubles. And so I put it in that public school, but no, I'm not wearing a mask. My child's not wearing a mask. No way.
Yeah.
So I am a mother of 4, and I am a Michigander, and I'm a proud Christian, and I'm a proud constitutionalist. And I am a licensed attorney. In fact, might as well tell you where I'm admitted to practice, because then you know how far I'm willing to take this fight. So I was originally licensed to practice in the state of Minnesota. Gave that license up, I don't know, 6, 7, 8 years ago, something like that. So I'm not licensed there anymore. But I am licensed here in Michigan, and in the Eastern District of Michigan's Federal District Court and the Western District Federal District Court. Saginaw Tripler Tribal Court. I don't know if you guys know this, but our tribes that are all around the state of Michigan, they're actually their own countries, essentially. So you have to be licensed in each and every one, just like you'd be licensed to practice in any other foreign nation. And most recently, a few years back, sorry, I just saw my car was moving. That's kind of creepy. I guess my husband's driving it. I don't know. He really wanted to hear me speak today, obviously. Most recently, I've been licensed to practice in the United States Supreme Court. So I am willing to take this fight all the way there and back and there and back, and however long it takes to get this sorted out, because I won't take no for an answer when it comes to our freedom.
Hell yeah!
So my role in COVID-19, well, I started by yelling at the TV on March 12th at 11:15 p.m. when she announced that she was closing schools for 3 weeks. And for my school district, I knew that was 4 weeks for those children to not have the supports and services that they need, because our spring break was abutted to that. Unfortunately, that was only the beginning, wasn't it? And I was the thorn in the legislature's side in the beginning of April, emailing them, calling them, going on radio stations, and spreading the word, trying to tell people, let your legislators know they cannot vote to extend the state of emergency. I was also one of the few here speaking on a much colder and rainier day on the steps of this Capitol here on April 30th, and then stood inside for 4 hours while we were trying to get into the session of legislature that we are unconstitutionally locked out of that day. I have continued to be a thorn in their side ever since, and I'm not stopping anytime soon. But let's not put all our eggs in one basket, right? So I am also the author and founder of the Restore Freedom Initiative, which is a constitutional amendment petition to end all of this garbage. People want to be mad at the governor, and obviously I'm not her best friend, but let's be honest, this is not a Republican-Democrat thing. This is a freedom thing, and shame on every single Republican and Democrat leader in our government today. Countywide, statewide, citywide, I don't care. If you are not standing up and defending the Constitution, you are violating your oath, and you need to be taken out of office now. Ooh, that's a whole nother thing. Let me go here first, okay? Because the recall is not a quick answer, trust me. So my other role in this is, and by the way, I stand by that constitutional amendment. It is going to do 1,000 times more than the repeal 1945. Okay, I'm not saying repeal 1945 is bad, don't get me wrong. But also the recall. I'm not saying the recall petition's bad, but this constitutional amendment is going to change all of it permanently, long-term, no ands, ifs, or buts. That's why we need 425,059 signatures by the end of November turned into the Secretary of State so we can get it done right. But like I said, I'm not going to put all my eggs in one basket because we got to keep the fight going. So I have continually filed motions and briefs with the Michigan Supreme Court and Michigan Court of Appeals on all these issues. Any case that is specifically related to these executive orders, with the unconstitutionality and the illegality of these executive orders, I am trying to be involved with and filing what are called amicus briefs. So I'm not representing anybody officially in any capacity. I'm filing saying I am a friend of the court system trying to offer additional information or arguments that the court needs to pay attention to when deciding these issues. And I have done that over and over again. And I have asked for oral argument time, but this last time I got a little bit more direct about that and asking for that oral argument time. It is extremely unlikely that any amicus attorney ever gets oral argument time in the Michigan Supreme Court. That's just not a thing. I was blessed to find out that it was originally going to be scheduled for this last Wednesday and now moved to this coming Wednesday. That I was, at least as of a couple days ago, the only amicus attorney allowed to argue in front of the Michigan Supreme Court on these upcoming issues. So now I have to explain a little bit about what this case is, because unfortunately the mass media, you know, the truth tellers that they are, and our Senate Majority Leader Mike Shirkey, also big truth tellers, right? People we can depend on. They've been telling people that the case in front of the Michigan Supreme Court this last week, which is now moved to this coming week, is the legislature's lawsuit against the governor. Who's heard that by any chance? Anybody think that's the case? Yeah, it's not. They've been lying to you. So the case in front of the Supreme Court, just so we're clear, it was only 2 weeks ago, I believe, that the legislature's lawsuit even had a decision from the Michigan Court of Appeals. It was Friday. What is today? It was 2 weeks ago Friday, okay? It wasn't until this week, I want to say on Thursday or Friday, that the legislature's attorney, Michael Williams, even filed the appeal with the Michigan Supreme Court. So they're not having oral argument already on that. What is happening is that there's a group of 3 or 4 doctor's offices and 1 patient in the greater Grand Rapids area who filed a lawsuit against the governor, the attorney general, and the Michigan director of the Department of Health and Human Services in federal district court. Also one of those courts I'm licensed to practice in. And what the judge basically said there, I'm trying to say this respectfully, is, why bother letting the country know, or this governor know, that she is violating the U.S. Constitution if we can get out of addressing that issue by simply addressing the state law and the state constitutional issues? So that's what they're doing. They're saying, well, if the governor has violated the state statutes, then we don't need to bother hearing the rest of this case. If the governor, because the plaintiff would win, if the governor is violating, or if the statutes themselves are violating the state constitution, the plaintiffs can win in that case. So why bother addressing any of the other points? Judicial efficiency, I guess? I don't know.
Judicial tyranny?
Yeah, we're not going to go there either, because that's a whole nother speech. So they did what's called certified questions. They certified 2 questions to the Michigan Supreme Court, asking them to answer, number 1, after April 30th, do the governor's orders violate the state statutes, the Emergency Management Act of 1976 and the Emergency Powers of Governor Act of 1945? Those are the 2 questions. So if she is illegal in that sense after April 30th, that's one of the things they want to know. The other thing they want to know is, do the 2 statutes I just mentioned violate the separation of powers clause of our state constitution and the non-delegation clause of our state constitution? So those are questions that I've been addressing over and over again in my briefs. So you better believe I was all over this one, asking for oral argument time. So trying to make sure I don't get too out of order here. I want to address that, but first, I sometimes I'm always a fixer, but sometimes I jump right into fixing without giving you enough of the why, or I might jump right into a business meeting without really stopping to say, hello, my name is Katherine, that kind of thing, okay? So let's back up and realize a couple of things that are super important that I want to bring your attention to, and then I'll go into the details of why I think it's super important that we all pay attention to what's going on this week in the Michigan Supreme Court. I'm going to talk about a little book I hope that you guys have heard of, Romans in the Bible. Chapter 2, verse 13 says that it is those who obey the law that will be declared righteous. I have not been advocating for civil disobedience at all. In fact, when I stood on the steps of the Capitol on April 30th and talked in front of thousands of people standing in the rain that day, I asked them specifically to follow the law and to follow the Constitution, and I demanded that of our legislators and of our governor and every other government official that we have. Romans 8:28. And we know that in all things God works for the good of those who love him, who have been called according to his purpose. I know without a doubt that I'm called to take up this fight right now, which is why I've given up all my paid jobs and everything else to work every single day for this. But he's calling each of you as well, because I can't do this alone. I'm just one person. And I'm honestly no more special, hopefully to my husband, but I'm honestly no more special than anybody else is here. Every single person here, whether you agree with me or not, you're needed, and you're important, and you're being called for this purpose. Also in 8, verse 37, no, in all these things, we are more than conquerors through him who loved us. We are more than conquerors. This is an uphill battle every step of the way. We have our legislators against us, really, pretending like they're for us. We have our governor against us. We have the Michigan Department of Health and Human Services against us. We have the Attorney General against us. We have so many pieces of the federal government against us. We have the media against us. We have our friends and neighbors and family members against us. We have a lot of churches, my own included, against us. This is not okay, but guess what? That doesn't mean we give up the fight. We are conquerors through him who loved us. And Romans 12:2 says, do not conform any longer to the patterns of this world, Look at what we are facing. We're facing 5- and 6-year-olds having to wear masks all day long to go to school. We're facing an executive order that says that when you go, oh, gyms, you get to open. You should be so lucky. Guess what? You have to wear masks when you're in your exercise classes and on the treadmills. I don't know if she actually said swimming, but she did say when you're exercising in the gyms that you have to be wearing masks. So we'll see how the swimming one goes. Too many are ignorant of God's word, including way too many congregations and pastors, quite frankly. We can't just pick on her, let's be honest. Of anyone who's serving in public office, absolutely, yeah. So Romans 13 is one that a lot of pastors have been using as reasons why we have to just follow the every whim of the government, okay? But here's the thing. Romans 13 says that everyone must submit himself to the governing authorities. Who really is the governing authority here in the United States? Okay, God. Yes, of course, God. In the human realm, who are the governing authorities here in the United States? The people. It says, Article 4, Section 4 of our United States Constitution, that this is a republic. A republican form of government is guaranteed to us, which means that we, the people, retain the power. And our government has gone astray on this for far too long. We also look at Article 1, Section 1 of our state constitution, and it says that we, the people, have the inherent political power. That means we are the ones that are the governing authorities here. We have these people that we elect to be representatives to do certain things for us at certain times within the constraints that we have given them, and they constantly step outside of that and take and grab more power and steal more power than they were given in the first place. That is not authority. Authority and power are not the same thing. They are trying to exercise power over us, but they do not have the legal or constitutional or God-given authority. That is a distinction that we need to make clear. So we are also told in Romans 13:7, give everyone what you owe him. And it talks about if you owe him taxes, pay him taxes. If you owe him revenue, pay him revenue. If you owe him respect, then pay him respect, etc., etc. We owe it to the people of the United States to continue abiding by the contract that is the United States Constitution. And we owe it to the people of the state of Michigan, whether we like it or not, to follow that Michigan State Constitution and make sure that all of our elected representatives are doing that as well.
Yeah, right.
Isaiah 1:17 tells us that we need to seek justice and rebuke the oppressor, and that's in talking to the people of a rebellious nation that Isaiah wrote that. Let's keep that in mind. So this is not just, oh, we're just supposed to blindly follow every government entity that's out there. And in the book of Ezekiel 2, verse 3, he was sent to a rebellious nation that had rebelled against God. Again, if the nation is rebelling against God, we're not supposed to be blindly following it. That is not following the governing authority.
Right.
And Ezekiel 11, verses 1, 2, and 4 talk about that when the leaders of the people are giving wicked advice in the city, God calls us to speak out against them, to speak the right word at the right time and in the right way. So what are we doing? What are you guys doing? Well, you're here joining me talking about this thing right now, and we need to make sure we are each going out and spreading this word on Facebook, on every kind of social media platform, talking to newspapers and radio stations, calling in, emailing television stations, emailing our legislators, emailing the governor's office, being that thorn in their side every single day, not taking a day off. I haven't taken a day off in 5 months. And neither should any of us, because we need to fight this fight. And if the evil isn't going to rest, neither do we. So in Psalm, we look at 31:24. Be of good courage, and he shall strengthen your heart, all ye that hope in the Lord. We need to have that courage to speak out. We need to have that courage to keep doing what it is that we are being called to do and not take this sitting down any longer. And in Psalms 56:11, in God I trust, I will not be afraid. What can man do to me? In reality, that's what we need to focus on, because the ultimate kingdom we're looking for is not here on this earth. It is up there. So we need to do what we need to do and sacrifice here and now so that we are doing God's will. And in Philippians 4:13, I can do all things through Christ who strengthens me. It's Christ who strengthens me. I tell you what, it's Christ who strengthened me when I was in that Capitol on April 30th and stood up inside and out for over 8 hours straight with the degenerative disc disease. I have arthritis and other debilitating back conditions, or to be at events just like this and stand here even for 20 minutes at a time, and I'm not in excruciating pain wanting to fall over. It's Christ who is strengthening me to do his work. And so if he can strengthen me in that way, he can strengthen each and every one of us in whatever way is needed to stand up and fight and do what we need to do. Doesn't matter if you're a teacher, if you're a stay-at-home mom, if you're a lawyer, a doctor, a judge, a garbage truck driver, it doesn't matter. We all have something we need to do here. So the last of those thoughts, I want to leave us with 2 Timothy 1:7. For God hath not given us the spirit of fear, but of power and of love and of a sound mind. That's something we need to remember, especially that sound mind. Let's think about that. So in having a sound mind and in following the law and in obeying the actual governing authority, we need to look at a few things. So if we look at our state constitution, it is riddled with ways that our government is supposed to step off our rights. Leave our rights alone. And it is riddled with ways that our government is supposed to be constrained and restrained from doing things. Unfortunately, these days it's set up so that we have to argue and prove how it is that we have a right to do something. I can't tell you how many times a day, and we're all conditioned to do it. I can't tell you how many times a day as an attorney I get a call from people all over the state asking me, well, where does it say that I have the right to do 1, 2, 3? Wait a minute. You want me to find in the law where you are given specific rights to do something? That's not how this works. The government does not give us rights. We give the government the power to do something or the authority to do something, and they don't give us anything. That's not how this works. We have that backwards. We need to make sure that we are remembering that. If you don't see a legitimate reason how the government has denied us the right to do something, then guess what? You have the right to do it, because we don't get our rights from government. We don't get them from Whitmer. We don't get them from the legislature. We don't get them from the Supreme Court. We get our rights from the Almighty God, and it says so in our U.S. and Michigan constitutions. What I hope to do is to wake up our entire government this week on Wednesday. And I'm going to get back to telling you, first of all, why that's going to be so hard. So in that case, it is now the governor and the attorney general and the Michigan Department of Health and Human Services, they're being sued. So they get oral argument time. The legislature is not being sued in that case, and they're not the ones suing, so they don't automatically get time. In fact, as of 4 days ago, they did not have any oral argument time. We're not going to be heard in the matter at all. So the way that it sits right now, though, they finally asked for the request to be heard, and because they were going to be heard, then the House Democratic leader said she wanted to be heard too, right? So we have the Republicans asking for their time, the Democrats asking for their time. Where is the people's time? Right. So the first 30 minutes of oral arguments scheduled to start at 9:30 in the morning this Wednesday. It will be available on the Supreme Court, Michigan Supreme Court's main webpage for live oral argument. You can also go to their Michigan Supreme Court YouTube channel. The oral arguments are actually going to be done by Zoom, so I'm kind of bummed that I can't be there in person to make the arguments face-to-face with these people, but it is what it is. So you guys can all tune in those other 2 ways, though. And at 9:30, the plaintiff's attorney gets to start arguing. So that is the person representing these doctor's offices and that patient. And they get 30 minutes to make arguments, and for the most part, I agree with a lot of their arguments. They have some really good arguments. But I obviously thought they were missing some key points, which is why I filed my brief and asked for oral argument time myself. I actually then am the next one to go. But as an amicus, I only get 5 minutes of oral argument time. So I'm grateful for the 5 minutes, but let me tell you, for how much I need to pack into what I need to say to them, I don't know how I'm going to turn into the Micro Machines guy and get through it all, because that's going to be insane. Oh my gosh, none of you are old enough to know what the Micro Machines guy is? I don't, okay. I saw no one going, oh yeah, back then, yeah. After me, the Michigan legislature's attorney gets to speak for 5 minutes because he is an amicus as well in this case. Afterwards, we have the, I think it's the Governor's Council, same attorneys representing the governor and the Michigan Department of Health and Human Services. Both of those are, they get total 20 minutes. The Attorney General's office gets 20 minutes, because again, they're parties to this case. Then the House Democratic leader gets 5 minutes, because now they're an amicus who gets to argue. So that's how this case will go. So just so you guys kind of know what to expect and how that's going to look and why. But really the main things that I'm arguing, well, let me just back up and say, I'm not blaming Attorney Michael Williams as though he's done a bad job or he's doing something bad or he's not a good constitutional attorney. I don't know enough about him to speak to that. I can tell you he's doing his job the way that he is constrained to do within the arguments that he's really allowed to make in the sense of representing the legislature alone. But the argument is essentially this that's been made. The governor is doing things unconstitutionally, and she's wrong because it's the legislature that should be controlling the people. That's what the argument is being made. I'd like to see anybody here think that you'd feel so much more comfortable if it was the legislature controlling you and telling you that you can't have your business open, you can't go to a gym, you can't go to church, you have to be wearing a mask and be socially distant and can't have family over for holidays. Okay, I didn't think so. So the thing is, in reality, they're both wrong, right? Everybody's out of bounds. What we need to do is remember the restraints placed upon the government in our state constitution, in U.S. Constitution, but I'm going to hammer the most on our state constitution because that's really the questions that were before the court this coming week. And on state constitution alone, we need to win. Freedom needs to win because our state constitution's not a bad constitution. In fact, my constitutional amendment isn't there to erase huge chunks of things that are just go to the core of who we are as a state. It takes away all the extra little garbage that's been added over the years and brings it back to where it began in the first place. So I think we have a great constitution in that sense. So we just need to make sure that we are encouraging our court, our Michigan Supreme Court justices to keep that open mind and keep focused on the main thing here, which is not who should have more rights to control the people. The judicial branch should have zero right to control the people. The legislature is not there to control the people, but to represent the people. And the executive branch is not there to control the people, but simply to enforce the laws that the people's representatives had put in place in the first place. So we need to make sure that those are the messages that we are sending. Now, something that recently came to my attention was buried in an email that came from the State Bar of Michigan, which is that there's this new little logo, I think she's calling it, that the Michigan Supreme Court Chief Justice, Bridget McCormick, has this lady justice who not only is blindfolded, but also now is wearing a mask. And she wants Michigan, there's like the Mask Up Michigan campaign that the governor's doing, and she wants it to be the court's analogous campaign of something like Mask Up Michigan Courts or something like that. So something to keep in mind, okay? Because she's encouraging every single legal professional, including our state courts, to have this on their social media platforms, to put it in their email signatures, to put information out about it, to tell people that, you know, you should be able to expect that you will be safe because masks are being mandated in these public places. So let's just ignore all science, I guess, and, you know, I don't know, a variety of other things, like the fact that we have rights to breathe and everything else. But those are some things that I would ask you guys to help me. Number one, by getting the word out this whole time. Spread it like wildfire. Get this information out so that people see how ridiculous this has all become. And know that people have a voice. So I know that we have felt so disenfranchised for so long, and we have been disenfranchised, but we can make that change. We can take it back. Absolutely. And I also would ask for prayer, because I need the most divine intervention possible for me to be able to speak in a 5-minute span of time and get it all in. Okay, so anybody who's heard me speak before or even today now understands that 5 minutes for me is going to be a big challenge. So anyway, those are the things that I would ask of you guys, and I was actually going to go into a bunch of the legal boring details about everything, and I can, but actually at this point I think I would just like to ask if anybody has any questions about anything that I've said at all.
How long will the arguments last for at the Supreme Court? Is this a decision being made on the 9th, or is it going to be a series of hearings?
It'll be the one day. So it's the 30 minutes, 5 minutes, 5 minutes, 20 minutes, 20 minutes, 5 minutes, and then the plaintiff's attorney, I don't know if they're going to give any specific allotted period of time, but it's on the schedule that they could address everything else that's been said, basically. So I've never added all that up, but that's how long it will be for oral argument time. As far as when the court will give a decision, I'm not actually sure about when. I'm thinking that they will fairly soon, because they've already, for lack of a better term, punted once, right? They were asked to take the legislature's lawsuit back in May, and on June 4th they said, nope, the legislature can't have the case heard, the appeal heard, before going to the Court of Appeals. And at that time, the governor and the legislature both agreed that the case should be heard in the Supreme Court right away. So the Supreme Court's already said, we're going to hold it off once to go through these procedures. And at this point, it's a federal court judge who's waiting to hear this answer back in order to determine a federal court case. So there's just more at stake. So I'm hopeful it will be within 2 weeks, but I don't know for sure. Any other questions at all?
Anybody else on our side?
Is there anybody else on our side? There's gotta be, but I don't know of a ton of people that are out there. I have thousands of people that email, call me, try to get me through Facebook every single day, and asking, like I'm a school bus driver. I just got fired because I can't wear a mask even with a medical exemption, or I just got denied services from having my surgery at a hospital because I'm medically unable to wear a mask, and now they're denying me medical services. The amount of things that are happening is disgusting. It's despicable. It's unforgivable, but I'm only one person, and I would love to know where all the other attorneys are that took the same oath of office that I did to defend the U.S. and Michigan Constitutions. So if you guys know of attorneys that are willing to do that, please have them reach out to me so that I can get them the business. They won't have to market at all.
Right.
Trust me.
There's Robert Barnes. He's actually, he represented the Covington kids, and I know he has a lawsuit against Whitmer. So I'm not sure if you're familiar with that. There's a big YouTube guy, Neo Fry, who he was a former litigator, but he does a YouTube channel and stuff. He's got a pretty big following. They've done some live streams with it, and they talked about a couple of different things, I guess he said that the 76 references epidemics, whereas the 45 does not, but they're just choosing to go with the one that grants them more power.
So To kind of touch on the point of how the 1945 and 1976 laws come together, there's some credibility to how the 1976 is more specific on that. The thing is, we have these canons of judicial interpretation, right? The way that we're supposed to look at laws.
Right.
And it's exceedingly clear, and by the way, this is cemented in my constitutional amendment, but anyway, until then, it's already exceedingly clear that what we have to do is if there's two statutes in conflict, which is a huge assumption that these even conflict, but if there are two that are in conflict, we have to look at the one that is newer. We also have to look at the one that is more specific over the one that is more general. Well, the 1976 one is obviously the newer one over the 1945, and the 1976 statute is more specific than the 1945 statute. So no matter what, the 1976 statute would prevail. The 1976 statute, though, does not totally, a lot of people have said, well, the 1976, the passage of that, oh shoot, now I just lost the word that people are saying. Basically, it supersedes the 1945 statute, and that's not exactly true. They work together. So you can't just look at the 1945 and follow that, or the 1976 and pretend the 1945 doesn't exist. But the point is that there is a provision, 30.417D of the newer statute that basically says, well, nothing in the Emergency Management Act, the whole 1976 set of laws, should be construed to diminish the governor's authority to declare a state of emergency. Well, it doesn't, and that's the point the legislature just keeps missing over and over again. It doesn't stop the governor from declaring a state of emergency, not in the slightest. The governor can still declare a state of emergency. It's just that the 28-day thing comes into play, and so she cannot keep extending a state of emergency. She has that 28 days without the legislature's approval, and if she doesn't get the legislature's approval, then she has to declare the state of emergency as terminated. That's how that's supposed to go. So basically the point is she's cherry picking which laws she's going to follow, and nobody's above the law. So why is it that she gets to pick which ones? I mean, otherwise I'm going to cherry pick which laws I want to follow, and I don't want to follow the property tax one because I have a big property tax bill coming up in a couple weeks here. I could pay the sales tax, though. I don't mind 6% on my gum and my food every now and then, right?
The judges, they should see this. It's like she's got the judges in her pocket.
Yeah, I'm especially disgusted with what happened at the Court of Claims because that judge was rock solid in her questioning of the governor's attorney and knew exactly what was going on. I have no idea how we got from what she did in the hearing to what we got in her 21-page decision. And at least in the Court of Appeals hearing, anybody who might watch my Facebook Live videos, I've told you guys that I knew it was going to be that way. I knew that it was going to be a 2-to-1, and I knew the two female judges were going to rule in favor of the governor, and the male judge was not. Because of their line of questioning. I mean, that was really obvious. So I don't know what's going on, other than we have lost sight of the fact that number one, we don't get our rights from the government, we get them from God. And number two, that the whole basis for the government to do anything comes from the Constitution. If the Constitution does not give the government that right, that authority to act, they literally cannot do it. It's that simple. And we have allowed all this other stuff to be created in these government bodies, and to the point that everything is so overly complicated that most people throw up their hands and they walk away because it's just too much to try to understand and get involved in. So anyway, hopefully that answers your question. Okay.
Why aren't the authorities acting?
Why aren't the authorities acting?
Yeah, why aren't
Oh, they're acting. They're acting badly.
Got you on that one, didn't she?
So, why are the authorities not doing their job, though? Their job, and just to be clear, anybody who, I probably didn't even say this today, but Article 6, it's not exactly called Section 3, but it's like the third part of Article 6 of our U.S. Constitution, and Article 11, Section 1 of our state constitution require anyone who's in the legislative, executive, or judicial branches to... That was special. At least it's not a human making that anyone who's serving in one of those roles has to swear an oath to uphold the U.S. and Michigan constitutions, period. In fact, our state constitution goes so far as to say you cannot be expected or required to swear any other oath. So you can't be required to swear an oath to uphold the charter, the city charter, that if you're, like a township, a city council member. You can't be expected to swear an oath to uphold the laws of the state, because there could be unconstitutional laws like we actually have here.
Slavery.
There's a ton of things to consider there, but it's something that we take for granted. But that's a very huge piece that we are required. All of the law enforcement officers, all school teachers, all public people, if you're a public employee, if you're a public official, you are required to uphold that U.S. and Michigan Constitution. So why they are not, I don't know, but we need to start holding them accountable. And again, just to kind of tie this in, we have seen the concept of governmental immunity being taken way too far for far too long. In my constitutional amendment, governmental immunity for intentional violations of our Constitution are a thing of the past. So, in other words, if we have any government official here in our state who is violating the Constitution, not just in the sense of violating individual liberties, it could just be violating one of the parts that's specifically constraining their authority to act. But if they are violating the state constitution and they are found responsible for that in a court of law, then that's a misdemeanor and they have to pay a $2,500 fine. If they're found guilty twice of violating our Constitution, it's a $25,000 fine, not up to, a $25,000 fine. It's a felony. They are immediately removed from office and permanently prohibited from serving in any kind of state or local government office ever again in our state. So why bother with recalls, which I think one of you had the question about how do we get her out of office? Well, it's a big nightmare, and it's such a cluster that I had to seriously spend 8 hours of my time going back and forth between all the different statutes that relate to recall, and specifically for the governor, just to be able to piece it all together and figure out what the time frame would look like. What other person is going to be able to figure out how many average Michiganders are going to be able to do that, be able to go back and forth and figure it all out and piece it all together. If the laws are not set up to be where everyone who's here can reasonably participate, understand, and act, take action against their government if necessary, then something has gone wrong. So it shouldn't take me 8 hours to answer a question for somebody about how something could happen. I mean, it shouldn't. So also something that's been a big thing, and you guys might have heard of the term standing to file a lawsuit. The governor is challenging that the legislature in their lawsuit that they even have standing to bring a suit against her. But they've also been challenging the standing of individual attorneys or doctors or other business owners to be able to sue her. So who really gets to sue her then if she's violating our state or federal constitution? In the constitutional amendment, I made that pretty darn clear. Anyone. If anyone wants to bring a government official to court and all they're asking for is to stop or enjoin that illegal or unconstitutional activity, they can do that. They have standing. Now, you're not going to be able to sue and then, claim that the government owes you a ton of money or anything like that. If your sole purpose is to bring somebody in, it could be a mayor, could be a governor, could be an attorney general, a state legislator. If they are violating constitutional provisions, you have the right to then just bring them in to court and get it stopped. That's in addition to whatever other civil remedies you might have available to you if they're actually violating your rights and causing you to be out money or things like that. So that is in our Restore Freedom Constitutional Amendment petition. But in general, they all do have that oath of office. So no one's following their oath. I mean, very rare is it to see someone who is following that oath of office. They're taking it seriously, and when they're not taking it seriously or not following it, how do we hold them accountable?
How do you make an example? How does that actually look like in practicality, bringing someone to accountability for violating their oath?
One of the main things that we could do is pay attention on November 3rd.
Right.
We should have been paying attention to the primaries, but quite frankly, I didn't do as good of a job as I would like to think I could have in helping to educate people on which candidates were going to be the good ones.
Yeah.
Far too many incumbents and establishment of either party were reelected, essentially, or given the nomination for their party. And I will, after this hearing, be focusing on making sure we are educating people on which candidates are on the ballot for November and who the constitutional ones really are.
Right.
So in the legislature's lawsuit against the governor, when there were the two Court of Appeals judges that ruled in favor of the governor, one of those is on the ballot this year.
Oh, yeah.
So we need to make sure we do something about that. And also, especially depending on how this case pans out next week, the Michigan Supreme Court Chief Justice Bridget McCormick is on the ballot. So paying attention to who's on the ballot and acting accordingly and voting and getting the word out and spreading the word about logistically who would be good candidates and why, and who aren't and why. That's one huge thing we could do right now. That's a quicker thing to handle than a lot of these other things.
Right.
And you know, all the other resources would basically be a lawsuit of some kind, whether it be some sort of criminal case or whether it be some sort of, you know, civil case. But again, when we're very limited on people willing to stand up and do the right thing, those who have sworn that oath of office, then it's hard to figure out how to get everybody to make that happen. But it doesn't mean that we forget or we, you know, just move on from that. It just means we don't have all our eggs in one basket, and we just keep trying all these other avenues until we get them out, and then eventually, hopefully, hold them accountable for what they've done to us now.
I know it would be kind of difficult with somebody that's as big as like the governor, but is there a way you can find like 3 instances of action that they've taken and show that they were violations of their oath, and you know, try to
Let that American
talk about
Patriot
what you
Council.
go with that action?
That is something that I was working with the American Patriot Council on when I was an active member of that. I honestly don't know where they're at with that right now, other than to say it's something we could follow up on. It's not something that we should give up on, but again, don't put all the eggs in one basket.
Gotcha.
And shoot, there was something else I was going to say about that. Darn it! What was your whole question?
Well, I don't know what I asked, but would it be good for city council people that are doing crazy stuff? You know, like there's all the city council people that are basically letting all the anarchists out, you know, and trying to defund the police and stuff in blue cities. Would you be able to do something like that, you know, as a way to redress the grievances?
Yeah, I mean, I think in the meantime, making sure that just talking to the city council members, talking to, you know, annoying the crap out of them, emailing them, making phone calls, showing up to city council meetings and demanding your public comment time. All of those things. I mean, you have a First Amendment right under the U.S. Constitution to have your redress of grievances. We also have a constitutional right in our state constitution to be able to petition your government for a redress of grievances. So absolutely, we need to keep trying to pursue those kinds of ways to address all that's been going on. Yeah. Hopefully it comes to me, whatever else that you said, it spawned a good thought.
No,
but
that was great.
Catherine, 18 U.S. Code, Section 242, the definition of law for the color of law. How does that?
241 would be the one to look at. 242 is based on specific. 18 U.S.C. Section 241 is the way to go if you're looking at federal statutes that would hold anyone accountable. If you have 2 or more individuals that are conspiring to deprive someone of their constitutionally protected rights, then they can be found guilty of a felony, and they can actually be punishable up to death if someone has died, like in the nursing home situations and things like that. That's what the 18 U.S.C. Section 241. 242 actually specifically narrows it down to a certain class of, basically if somebody is doing so on a discriminatory basis of color, or I forget what the other specific things that are listed in that statute. So I don't know why they're so close together in the statute numbers, but 242 is basically a whole different ballgame. 241 is the way to go. You also have 42 U.S.C. Section 1983 claims, where it's a civil claim if you have somebody who's trying to step outside, a governmental official who's trying to step outside of their authority, and in doing so is violating your rights. Then you have a 42 U.S.C. Section 1983 federal claim against them as well.
Why haven't those been brought up before now?
I believe that the American Patriot Council, I believe, and that's one that I've been talking with Jason and Ryan about for months now, is that would be the criminal way to handle those. I don't know to what extent they're utilizing that conversation with FBI or Department of Justice or any of those, entities that they're reaching out to. But I do know that the 18 U.S.C. 42 U.S.C. Section 1983 claims are ones that have been raised in the federal cases, and that's kind of, a lot of them, I'm assuming that's the main basis for them getting into federal court and having their constitutional rights trampled on by our governor in all these situations. Oh, I do know of, okay, my thought came to me. So one other thing that you guys could be doing, just, it has been a question that was asked of me, but the way that you asked the question, and I forget exactly the wording you said now, but what can be done when we have, say, the governor or the Michigan Attorney General who are violating their oath of office, if there's 2 or 3 or 4 things that are specific that they are doing to violate state law, violate their oath of office, and misstate the law, they're licensed attorneys. The Michigan Attorney Grievance Commission has a procedure right online. So if you file grievance against the Michigan Attorney General as an individual licensed attorney, or the governor as an individually licensed attorney, then the Michigan Attorney Grievance Commission would have to at least look at that. So, for example, if you filed a complaint, and you filed a complaint, and you filed a complaint, et cetera, et cetera, et cetera, be something they might want to start looking at.
Right, yeah, they add up.
So violating the state and federal constitutions is, in my book, a big no-no. So you would think that if enough complaints get filed with the Attorney Grievance Commission about that, something would have to start being done.
The Attorney Grievance Commission, that's the process.
Attorney Grievance Commission, yep.
How are you dealing with when you walk in a place of business and they tell you you gotta have a mask on shopping? What's your reaction?
It depends on the day. I'm going to be honest, I'm human, and it wears on me to have to fight. I'm obviously not afraid to fight anybody in terms of doing it the right way, right? I mean, I've challenged our governor, Michigan Attorney General, any of them. If you guys want to have a debate here on the Capitol steps, Gretchen, or Nessel, if you guys want to debate me, I'd be all for that. Oh, I'm not, it doesn't, you know what? Doesn't even matter on the science, though. The science I could beat them on, absolutely. And I have some really good expert immunologists and epidemiologists and whatnot that, doctors, all kinds of medical professionals that I can lean to for those, the medical resources. But regardless of what the statistics say on the math, on the medicine, on the science, on any of that, the Constitution remains. And that's the thing. I don't have to even bring that up when it comes to this oral argument on Wednesday, because, and maybe I need to, the point you raise is good, and hopefully I can remember to say this. It doesn't matter about all those other aspects. None of that should even be considered, because the Constitution is the Constitution is the Constitution. And the Constitution does not have an exception for emergencies. It doesn't have an exception for pandemic, epidemic, the common cold. It doesn't have an exception for, if there was some sort of thing where it's killing off half the population. In fact, our state constitution, Article 4, Section 39, specifically says that in times of emergency, when it's a state of emergency, our state and local governments have to continue in their operations. Did you guys know that? There's an actual provision in our state constitution that says that. So I agree with you on the math, science, whatever, but we don't even need to go there because that's not what is, we still have the right to choose what is right for each of us individually. So
The child doesn't have a choice. For my 5-year-old to go to school, he has to have a mask on. Cut out the
Yes.
breathing, cut out his oxygen. He needs, it's biology 101. He needs the germs.
there's a lot of other things wrong with a child having to wear a mask going to school. Absolutely.
About the mental.
Exactly. The spiritual, the mental, the physical, the medical. There's way too many things. So it's unfortunately not an easy thing because do they have the right to do that? No. Do they have, do the school systems have the right to put those policies in place? No. Do the school transportation departments or whatnot have the ability to let people go because they're as school bus drivers or teachers or parapros are not able to wear the mask? No. Do stores have the right to deny people services because they can't wear a mask? No. But they're all doing it. So what's the Staples Easy button? I don't know. When you find it, please give it to me. But I'm working as hard as I can on how to fix that, which is why I told you guys each and everything that I'm trying to work on in all those different areas, because that's all I got. I'm utilizing, I've never been about civil disobedience. I'm trying to utilize every possible tool of civil obedience available to us because we have the law on our side, we have the Constitution on our side, and we need to persevere and know that when we have God on our side, we're going to win. And we just need to keep at it until we get it done.
Amen.
Any other questions?
So I see this thing, I heard about the Michigan Court of Claims, and it kind of, they say, now correct me for whatever I'm saying that's wrong, but I understand that it seems like you have to go through the Court of Claims in order to actually sue the government. Now what that really reminds me of a lot, originally, is the vaccine injury fund, where you can't actually go again after vaccine manufacturers. You have to go through the vaccine injury fund. Now this is the court.
They're two totally different things. They are two totally different
They're
things
totally
because with
different?
vaccine injury claims, you don't actually ever get into a court of law. In fact, the statute specifically says you don't have that right, supposedly, to sue a vaccine manufacturer because there's a vaccine injury. So let's not even get me started on the whole vaccine injury thing, because the very first brief that I filed as an amicus attorney in 2020 this year with the Michigan Supreme Court was on the issue of vaccines. So if you guys want to look at that, you would probably love to see what I wrote there. And how I used the Court of Appeals judge's words against them and the ridiculousness. But that again is like, that's a 3-week long speech right there. So Court of Claims though is, as much as I don't like it for a variety of reasons, the sense of having a Court of Claims itself is not the problem. The logistics behind it or attached to it or being able to utilize it are the problem. But Court of Claims makes it just one central place where if you want to sue the government, then it makes it easy for you to know, oh, you're going to go to the Court of Claims. So in that sense, it's okay because it's still a trial court proceeding that's happening. You have trial court procedures, rules of court, the same as you would if you sued at the your local county, court. So that doesn't take away your rights, but the vaccine injury stuff, absolutely. Those are 100% deprivations of our right to participate in the judicial remedies available to us otherwise, absolutely. Yeah.
Question a little bit different. All of these laws or these executive orders that are in place they're affecting kids with the mask.
Sorry, one pause. Executive order is not law. And I know you didn't mean to say that.
Yes.
But for anybody watching my camera right there, executive orders are not laws, period. The only way you can have executive orders, and I'm not staring at you.
I know, camera.
Are Article 5, Section 2 of our state constitution that allow our governor to reorganize parts of the executive branch, and only if she gives that executive order over to the legislature and gives them either the 60 or 90 days, and I can never remember which one it is, of time to decide if they want to disapprove of that. And so if they take legislative action and they say, no, we do not approve of that executive reorganization, then it doesn't happen. Otherwise, it does. But the only thing she could do is reorganize the executive branch. She cannot regulate the people with those executive orders, and nothing in our state or U.S. Constitution allow her to create an executive order that means that it has the same force and effect of law, period. And the law we can't just blame the governor for this, because those two statutes we talked about, they do violate the separation of powers clause, because they specifically allow her to create executive orders or proclamations that purport to regulate the people. But guess what? So in law school, we're taught that if you have, in property law, you have a bundle of sticks, right? So if I have property, I can only give to you, I can only give you a warranty deed for the property that I have, right? I can't give you more than what I have. I don't own the house that's over there, right? So if I say to you, I'm going to sell you my property that's over there, I'm going to give you the nothing in my hand, right? Because I don't own that. The legislature did that with these statutes. They did not have the right to regulate the people by executive order. So if they don't have the right to do that, they can't give that right to a governor. So it is in there, but we need to blame our legislature from 1945. We need to blame the legislature from every single session afterwards, as well as the governor for utilizing that executive power in that way. Sorry, that is not what your question was, but I needed to clear that up.
I was trying to, my question comes to on our everyday lives. Like we talked about kids going to school and the mask and the bus driver. We're tracking and tracing to go to work, using apps that go to MDHHS to track our body, our temperature, our all these things that are directly because of the executive order. How do we push back on that, and what can we do around those kinds of things as citizens?
Did you say you're specifically asking about the contact tracing and the
to get into my job, to go to work? You have
is it in the private sector?
Well, public.
Either way, we all have the right to our bodily autonomy. We all have the right to, have bodily integrity. And so that's why I was really disgusted with the Republican-led legislature that the House Bill 5672, when it proclaimed that it was this good thing that was stopping employers from basically forcing you to have any kind of device, it was called, but microchipping or anything else like that. But what the bill actually said is, well, they can. You just have to have a court to order it. But even if they don't get a court to order you to be microchipped, the employer can still do it. It's just you can get actual damages from them. So meaning, if you go and get microchipped or you're forced to be microchipped as a condition of employment, which is the severe example compared to what you're asking about.
Yes.
Then this bill, 5672, which I believe is still in limbo here in the legislature. I don't know what the current status of it is. But it passed the House by 104 votes. 104. That tells you almost everyone on both sides of the aisle voted in favor of this bill, which said it's okay for a court to order you to be microchipped as a condition of employment, and that if a court doesn't even give that permission to the employer and the employer does it anyway, the only thing you can do is get actual damages, which means that if you are out, I don't know, you get the microchipping and you have some sort of medical complications and you have a $500 deductible for your medical care, all you can sue them for is the $500. That's what actual damages means, and you'd have to prove it. You have to bring receipts and have your witnesses and exhibits, and it's ridiculous. What should be in there is no provision that a court can ever force a human being to be microchipped. I don't care if it's through a criminal case, I don't care if it's through a family case, civil case, I don't care if it's an employer. There's no condition under which a court should ever order a human being to be microchipped or anything like that. Nor should a person ever be stopped are limited to actual damages. If an employer ever tried to do that to you as a condition of employment, you should be able to get not only the actual damages, the cost that you're out, you should be able to get the punitive damages and what are called statutory damages that the legislature should determine ahead of time. If you have to be bringing a lawsuit like this in the first place, as long as you prove they did it, then guess what? You get X amount of money right then and there. It needs to be incentive. It needs to be incentive so that these employers don't pull this garbage. So shame on our legislators, all 104 that voted in favor of that bill so far. So anyway, related to that topic though, of in order to go to work, having your temperature taken, having to give information on where you've been, and have that whole contact tracing thing going on, that's not constitutional in the slightest. No person has the right to have that much information from you unless there's been a warrant. We have a Fourth Amendment right to be free from unreasonable searches and seizures, and to have somebody check your temperature every day and ask you for your physical symptoms that you might have. If you've had a scratchy throat or a headache or anything like that, I'm sorry, that's none of their business. And where you went, they don't have a right to know that. The government doesn't even have a right to know that if you've been charged with a crime, and unless there's a specific warrant there for a particular reason, they can't do that. So I don't know what the again, I don't have a Staples Easy Button answer on that, unfortunately. Do they have the right to do that to us? Absolutely not. And we just need to keep standing up and fighting against it and saying no. But how to do that, I honestly don't know what is the easy answer, because in the interim, what does that mean? A lot of people are going to have to be willing to not have their jobs right now. They're going to have to be willing to stand up and say, no, if you need to fire me, but I'm not doing this.
What about the private sector and, say, the vaccine that's coming out?
Same thing. Absolutely same thing. That's whether it be the microchipping, whether it be a forced vaccination. There's no right of a employer or a governmental entity to force you to put something into your body to be able to work there. That's beyond ridiculous, not constitutional, and doesn't comply with any notions of the fact that we got our rights from God. But
company policy?
Company policy means jack.
Because that's what's coming. So we all know that's coming.
I need a copy of that video. Take it to work.
A company policy. I mean, let's look at to the point of absurdity, what that means, okay? Because I know that two of the legislators that actually voted against House Bill 5672 did not vote for the right reason. They actually voted for terrible reasons. They voted because they voted no on that because they said, well, it restricts the employer in some kind of way, and no employer should ever be stopped from requiring something as a condition of employment, because we have a we have a free market society where employers should be able to require anything they want. It's just part of the contract. Well, yes and no. I understand their point, right? I'm a small business owner. I should be able to require certain things or not require certain things, but to require somebody to inject something into their body to work for me, there's no reasonable way that should ever be allowed. But yeah, company policy to take your temperature, company policy to know exactly where you've been, it's none of their business. And so for a company to do any of those things, I mean, it goes, again, if you're kind of a libertarian in nature, I don't know why you would think that for these two that voted against the bill, because of the libertarian side of them that said, well, you should be able to make a contract to do whatever you want, but then you shouldn't be able to have the a person give a right to a company with disparate bargaining power to force you to provide that information, or infringe upon your liberty to whatever, go hang out with friends or family, or go drinking the night before if it's not going to impact your ability to function at work, and you come to work and you have a hangover and you have a headache and you have a slight fever. I mean, that's none of their business. If you're going to be there to do your job, you're there to do your job, period. So, man, there's a lot of Staples Easy Buttons I need to order on this topic. Any last questions? Yeah.
Okay, so I had a lady come
I decided I don't want any questions from you, Mary. Sorry. I'm just kidding.
You remember my name? That's awesome. Thank you.
Oh, and I know you're going to be at our thing in Sterling Heights, too.
This woman called me last night, and she wants to get circulated. Okay. She has a bunch of kids, but two of them are still in school. One of them is deaf. Another one has Asperger's. Okay. Originally, the school system said, oh, well, yeah, we're going to do it all in person, and they have to wear a mask. So she wrote to the superintendent and said, even though my daughter has hearing aids, she doesn't have full hearing. She needs 3 lips. And it was like, oh, too bad, so sorry. It's not our decision. It's the government. Okay.
Funny thing is, hold on, the executive order 153 specifically allows for people to not wear masks when they are in conversation with or trying to communicate with somebody who is deaf or hard of hearing or has a disability where they need to read lips. I am one of those people, so my husband and my children do not wear masks anywhere we go for any reason, because my disability says that I need to be able to read lips in order to communicate with people, and I try to tell people in stores that as we go places, and it's amazing how many people are just buttheads about that.
Well, so, I mean, in any case, so they decide they're going to do all distance learning, okay? Her child is Asperger's. She's like, there's no way. This child cannot do distance learning.
Does she need ABA therapy?
I don't know exactly. I was so livid last night, my head was going to blow up.
Because ABA therapy specifically is for, among others, children that are on the autism spectrum.
Okay.
And basically it's a big sensory thing, right? And so there's a lot where they need, like a weighted blanket at times to utilize, or all these other things, right? And so when schools are saying, well, we're going to provide the IEP stuff or the 501, 504 plans to students, we're going to go ahead and do what we need to do under that, but we're not going to have human contact. You're not going to be within 6 feet. The adults and students are required to wear masks. That in no way, shape, or form does anything to provide the services that those students with special needs need.
I guess my final question about that is, so what kind of a case would that be? Would that be like against
Everyone. No, I'm serious. I don't even know where to begin with that, because you have the service providers that are not doing their job. You have the school administrators. You have the school board members. You have, to a certain degree, I guess the Michigan Department of Education. You have the governor's orders. The official orders don't seem to really require those things to happen, because the actual orders acknowledge that there's physical disabilities for which you don't wear masks or utilize those other, social distancing protocols. But yeah, obviously it's coming from the governor going down to these other agencies. So I would sue everyone. Which one? Oh, the executive order that has the exemption in there for, yeah, that's Executive Order 153. It is, I don't remember what section it's in. Michael, I need Executive Order 153. Can you tell me what section that exemption is in for the hard of hearing? I honestly don't know the answer to that, other than the thing is, yes, they should be, but here's the problem. Let's look at that one example we just looked at right there. Can you think of how expensive that example is going to be for us as a country or us as a state? I mean, the millions of people that are being discriminated against, the dozens or countless amounts of ways that just me, I'm just going to focus on, when I have a hearing disability, I have breathing problems, so I have my own medical exemption for a mask. I also have the exemption related to how others around me, etc. The amount of ways that I have been denied services or been discriminated against or yelled at in a restaurant or embarrassed or ridiculed or anything like that, the amount of lawsuits that it would take to redress all of that and put it all in check just for one person is insane. So the expense that would cost is more than our economy. I mean, it would do more than the COVID stuff does alone. You know what I mean? The amount of ways that people are doing wrong because of this is so exorbitant that the price tag would be more than we can afford. My doctor did give me, although I've been so busy, I need to ask him for a letter that explains right in there my hearing disability, so I don't have to keep saying it over and over again, and I could just show people. Not that I have to show them, but just because I'm sick and tired of having to explain it to people. Okay, but G what? G2. Okay, so paragraph 2, I thought it was 2, that's weird. Paragraph 2, or section 2 of Executive Order 153, subdivision G, gives you that exemption for if you are communicating with someone who is deaf-blind, or hard of hearing, and where the ability to see the mouth is essential to communication. So if you have somebody who reads lips and has a disability and they need to read the lips, you cannot have a mask. Again, you're not required to wear a mask anyway because an executive order is not a law. But too many people don't realize that. Absolutely. Any last questions?
How many will take a petition home and have signatures collected for this amendment?
Awesome.
See this woman right over here with the purple sign?
Tammy.
Tammy?
All right, Mary and Tammy are captains that can train. So, Mary, can you wave around again and dance? Yeah, okay. This is Mary and Tammy. Where's Tammy?
What is this for?
Tammy, can you wave, Tammy? Okay, that's the other woman that can train you to get you to be a circulator to get signatures for our Restore Freedom Constitutional Amendment petition.
Somebody mentioned it's at 400,000 people right now.
That's the 1945 law.
No, they're not at. They're full of crap. Don't believe that garbage. They also tell you that the 1945 repeal is going to take care of all the executive orders. That's not going to happen either. But anyway, sorry, I won't even go there. We need 425,059 signatures is the total that the law requires us to have in order to get it on the ballot. Where we're at right now, I was actually trying to crunch numbers before I left here today, and that was one of the 12 things I was doing that made me 10 minutes late to my 4 o'clock time to arrive here. So I don't have all the numbers off the top of my head, but my goal is to break down numbers for each individual county and have numbers available so that I could tell you as of 3 days ago, we needed 14,859 more signatures from Kent County. And we have 180 circulators and captains in Kent County, so we can make that happen in the next 10 weeks. I could tell you that in Wayne County, the total amount, now this is not including what we already have signatures for, but the total amount, and this is not a legal requirement, this is just logistics, how to break it up so it's reasonably attainable goals for each and every person in our state, right? But 76,354 signatures is what we would need from Wayne County in theory because of how many voters they have there. So my goal is to reach out to, throughout the course of the next week, each and every county to say, hey, this is how much you have. What was that?
We're from Wayne County.
How's that where you're from? I need your help. Okay, well, when I get off the mic, I'm going to talk to you guys because I need your help. So, yes, thank you so much for coming, everyone. Have an awesome day.